The first of the weekly seminars on international interdisciplinary PhD in progress. This is phase 4, and it is organized by the Global South Network. The phase will continue from January 2025 until the end of this year, December 2025. I would like to start the session by thanking the organizer of the series, Dr. Norman Riat, is a lecturer in law at Leicester University. I'm Dr. Taiwo Oriola from University of Derby. My research interest and teaching interest are in IP law, IT law, and data protection law. So I'm joined by two discussants. Our first discussant is Dr. Georgia Jenkins, who is a lecturer in the School of Law, University of Kent. Our research adopts a critical perspective and considers the social and cultural context in which the IP system operates and influences the expansion of protection to the detriment of public interest. So, and currently she researches in relation to creativity, both within the EU, copyright law, and trademark law. Focusing on music sampling and non-fungible tokens. Georgia was previously a lecturer at the Center for Commercial Law Studies, Queen Mary University in London, and she recently completed her PhD as a Herschel Smith Scholar at Queen Mary Intellectual Property Research Center. Our second discussant is Dr. Patrick Masiyakurima, who is a senior lecturer in law at CC University of London. We also have a peer commentator from Brazil, and he is Bernardo Carvalho De Mello. They are a dedicated Brazilian legal professional who began their legal career as a senior partner at the esteemed law firm Goodman and Associates, and later served as a consultant lawyer at the Secretariat, I think, Director of Humanities. Sorry, I don't speak Portuguese. And in Rio de Janeiro, where they actively contributed to the protection and promotion of human rights. Bernardo is currently doing PhD in law, specializing in international human rights law at Newcastle University, showcasing their commitment to staying at the forefront of legal scholarship. Their previous academic achievements include a master's in constitutional law and state theory, and a bachelor's degree in law, both in Brazil, and a BA in history. Last not least is our speaker today, Minji May, who is a PhD candidate at the School of Law, University of Glasgow. Minji, you have 30 to 35 minutes for your presentation. And before you start, I just want to lay down the rules, because this is a 1-hour presentation. Discussants, they have maximum of 5 minutes each to make their contribution. If you exceed your time limit, I will kindly remind you of that. And after the discussants, we will have a peer commentator as well. They will be invited to make their comments, and thereafter we will refer to the audience to comment on the presentation. Okay, so it's over to you, Menji.
Thank you. And hi everyone, my name is Mengyi Mei. I'm fourth year PhD student in the University of Strathclyde Law School. And first, I would like to show a big thanks for all of you to coming after a new year to listen my presentation in here, and also wishing you all have a good new year in 2025. And also I appreciate that the Global Sales Network can provide me this invaluable opportunity to present my research with such amazing a research group here. So the topic I would like to talk about today is how to effectively regulate the copyright infringement issues in short videos on short video sharing platform by comparing the copyright framework in China, US, and the EU. So first, at the beginning, I would like to introduce the background and significance of my research briefly. And in the past few years, short video have gained a huge global popularity due to its short duration, fast transmission, and simplified production and editing process. And also another important the reason why they're being so popular is the short video sharing platform in China. They have a very powerful connection with the e-commerce functions. So it means they have a strong connection between the user-generated contents and e-commerce. So, and more specifically, the most online users in the short video sharing platform, they have a big chance to create their own business or earn money from the content they post online connecting the e-commerce. So that's the reason why they're being more and more popular currently. And also in those elements, they have a gratefully increasing the user numbers and market scales and commercial values for the short video sharing platforms. However, it also leads to a huge challenge for copyright law to regulating the short video copyright infringement currently. And first, I would like to start with the Chinese perspective for the reason why they're being so serious in currently. And first, there is a number of infringing short video exists on the platform currently. And even though the government, they are trying to take down as much as possible for the infringement short video from the platform, but there still have a large number of infringing short video exists on the platform. And in that case, it means the administrative enforcement in that case is not working very efficiently. And also from the court report, the number of the relevant cases in short video also increasing year by year. And also due to the characteristic of the short video, they also have a various and very changeable infringement type on the platform as well. And also, and from the whole intellectual property area for the short video, the copyright infringement is the most several issues, particularly on the short video sharing platform. And also there is a data shows that currently the short video sharing platform is becoming a very high risk area for the short video copyright infringement. So based on what I talk about and also from the cases, it shows that the copyright law starting to become an excuse for short video sharing platform to avoid to bear the liability for the copyright infringement. And also, the platform are becoming an assister to tolerate and promote those existence of a massive infringing short video on their platform. And the main reason is this kind, and those infringing short video platform can bring a huge advertisement profit to short video sharing platform. So, and that's the reason why they are trying to pretend they're not seeing those infringing short video platform on their platform. And another significant reason is maybe everyone seems that it's a Chinese issues, but in the fact that this literally an international issue, because currently the overseas short video sharing platform are facing the same challenge as well. And also from those platforms, you can see they're starting to appearing the similar or even the same type of infringing short video on their platform. So based on what I talk about, the main argument of my research is my research argued that the current provision of copyright law in China and the US is insufficiency for regulating the seriousness and repeating and frequency of massive copyright infringement issues in short video on short video sharing platform. And when I talk about research gap, and I would divide it as two perspectives. First is from China's literature. They are more focusing on like how to address the general short video copyright infringement or the secondary creation of short video copyright infringement, and also, they are more focusing on addressing the Chinese short video copyright infringement in here. And also, when we look at the US or EU's literature, there is extremely limited research on copyright infringement in short video area. So in this case, my research is not only addressing the issue in China, I'm more deeming it as an international issue. So my research also considering whether the current US and EU's copyright framework can effectively regulate the same issue or not. And my research also more focusing on address the massive and frequently repeated or reappearing copyright infringement in short video so far. So combining the above, the central research question for my research is to finding out how to effectively control the massive and frequent repeat copyright infringement issue in short video on short video platform. And then I also divided 3 sub-questions based on the relevant provision of the copyright law. And my thesis, each chapter is answering the each questions as well. And also later on, when I did talk about my findings, we're also answering the each sub questions too. And the methodology I use in my research is black letter law, case law, and comparative legal research. And that's my research contribution. First, I'm conducting a comparative analysis of the relevant provision in copyright law in China, US, and EU. And the objective is to draw on the lessons from the US and EU to see whether China can truly learn from it and truly effectively control these issues in China. Also, I believe China's short video copyright issues present a valuable lessons not only for its own copyright framework, but also for the US and EU. So both countries can also analyze this issue to evaluate if the same seriousness of short video copyright infringement also happens now, if their existing copyright law can effectively address the similar issues or not. So that's the general research introduced about my whole research. And then before I move to findings, I would like to provide 2 main research contents. First one is about the definition of the short video and short video sharing platform. They don't have a very official or uniform academic definitions now, But after my research and the summarize from all the possibility and it can be defined as the short video is a short length video within 3 seconds to 10 minutes, and the short video sharing platform is the platform have a specific fundamental function for recording, editing, and uploading those short videos. And I think the most classical example is TikTok, because that's the platform specific for the online users to sharing the short video content. And the second concept is called safe harbor provision. That's the relevant provision I mentioned before under the copyright law, and my research also is the main discussion is surrounding how to like improve the safe harbor provision to strengthen the duty of care, duty of filtering, and duty of monitoring for the short video sharing platforms. So as the slide shows, safe harbor provision is constituted by two main parts. The first part is a front-end disclaimer condition. As I showed, there is a few conditions below that. And then the second part is called after-event remedy mechanism, which called notice and takedown procedures. So based on these two parts, when it processes, it will have a two situation. The first, if the platform have actual knowledge or awareness about such infringing activity on their platform, and then they need to take measure to stop it. And if they don't have actual knowledge or even they are not awareness of those infringing activity on their platform, and then if you go to the second part, which called notice and takedown procedure, it means like the right holder will send in the notice about the alleged infringing videos, and then they need to take a necessary measure based on the notice to take down the infringing short videos. So if they didn't satisfy those elements, they won't be able to successfully apply the safe harbor provision to prevent themselves from the online users' copyright infringement behavior. And then they also need to bear the liability for secondary infringement and the compensation. And safe harbor provision also first introduced by the DMCA of 1998 in the US, and also in 2006 China mirrored by the DMCA safe harbor and then have a Chinese safe harbor. But in the fact that they are sharing a very high similarity safe harbor provision at the same time. And the differences is the EU copyright directive, they are not applying safe harbor anymore. So it means they're using a new regime, innovative regime to regulate this kind of issue. So later on, my finding will also explore more about that. Now we move to the first finding. And after my research, I realized that the characteristics and the capability of short video sharing platform need to be re-identified. As my slides show, under the US Copyright Act and the Chinese Safe Harbor, they all deem short video sharing platform as a information storage space. And also because they deem that as however, I think currently from the development of short video sharing platform, it's already go beyond for a pure information storage space so far. However, after comparison, I found that the EU copyright framework provides a more accurate positioning of the short video sharing platform, which called online content sharing service provider. Like the EU copyright directive create a specific service provider for those video sharing platform. And the most important thing is at the Article 2 of the EU copyright directive, they also started to recognize that this kind of platform is organized and promote for profit-making purpose. It means they are not making profit for people storage their information. They have strong connection with the online contents for the people who sharing on the platform. So, and also there is another act called EU Digital Market Act. They also put YouTube and TikTok into the list of designated court platform surveys. I think all these changes under the EU context can indicate that the EU copyright law and the market there realize that and understand how the commercial value of those video sharing platforms that can make. And so at the end, I think short video sharing platforms capability now is significantly surpass the traditional legal classification and perceptions. So it also indicates a need for a re-evaluation of short video sharing platforms' roles and functionality in the digital landscapes under the safe harbor provisions. And the second findings is about the front-end disclaimer condition of the safe harbor provision. I think for the safe harbor provision they have now is too uncertainty and difficult to determine if a short video sharing platform need to bear the liability for copyright infringement. And also, I believe now is the time to consider a new regime or reform the safe harbor provision for more clearly to determine the liability for the copyright infringement on the short video sharing platform. And after the comparison, I feel like the EU copyright directive is a very good example because they have waived the old or traditional safe harbor regime since 2019. And then they also established an innovative mechanism to strengthen the duty of care and prevent the repeat infringement by copyright law. And they also stated the different scales and commercial value of different online content sharing service providers should undertake the different level of duty of cares. So I think after the comparison, the EU copyright directive can more effective in controlling the short video copyright infringement issue. I think particularly they are putting the short video platform to make more effort to prevent the repeat infringement issues. And now I'm showing you one of the example for the China's safe harbor provision. As you can see that Article 2022, they deem short video sharing platform as an information storage space. And because they deem it as an information storage space, it means they can't change the work on their platform. And then they use that as an excuse to say that because the law said I can't change, so I can't make any efforts or I can't take down any infringement or any videos in advance unless people telling me and notice me that's infringement. And then because their information storage space, so they should not know and they should also have no reason to know what kind of information is infringed or not on their platform. And also because of the information storage space, they should not and have no reason to receive the financial benefit directly from the user-generated contents. So under the safe harbor provision, what they can do, the only thing is they're sitting there to wait for the people to send in them the note about the infringing short video, and then they just take down the infringing videos from notice by the right holder. And that's all the responsibility and obligation for current short video sharing platform. And also, as we can see, that's the US safe harbor provision. They're sharing a very similar provision. And also, the only difference is the US, they mentioned that at the B section, they mentioned that which the safe harbor provision have the right and ability to control such activities. However, in the the practice, and because they are only providing a system or space for people to upload information, so it means they should not have the right and ability to notice the infringing information, and so it means they also they don't have that ability to control such activities on their platform. So all those terms shows that the difficulty to determine how short video sharing platform need to bear the copyright infringement based on current safe harbor regime. And that's the reason why I said that the current front-end disclaimer condition of safe harbor provision is insufficient to regulate the massive short video copyright infringement issues so far. And finding 3 is talk about the after-event remedy mechanism, which is the notice and takedown, also lack its effectiveness in regulating the short video copyright infringement issues as well. And unfortunately, neither the China, US, and EU's copyright framework have developed an efficient mechanism for effectively for helping the online users or right holder to discover the infringing video in advance or proactively protecting their right, because the current regulation, they are all prefer to have a passive supervisions. And now I'm using this small phone to show why its lack of its effectiveness for regulating the issues. From law, the notification will send by the right holders, and then the platform will receive the notification, and then they need to take necessary measures to take down the infringing materials. That's how the law say that. So following that, they will have a 2 pathway. The first is, yes, if they did that, they can successfully applying the safe harbor provision. However, maybe you think, okay, yes, they delete the things. It means the infringing video will only stop here. But the situation is not like this. The situation is they only delete the infringing video which named by the notification from the right holder. It means if go beyond, if even the same type or even the same infringing video go beyond the notice, they don't need to take down that part of an infringing video. So it means if the same type of infringement video record or reappearance, the only thing they can do is go through the whole process again and again and again. And the result is the same type of infringing video will never end in this process. And the second pathway is there also is a real case in China. Even they received the notice from the right holder, but they still didn't take any measures to delete the infringing material as well. So if everything goes well, and luckily the things can go to the court, because it's not every dispute can successfully go to the court. But if the dispute can go to the court, and there is a high chance that platform will bear the liability for the copyright infringement and the compensation. And maybe in here you think, oh, now court is already tell you it's infringing, you need to take it down. Maybe in that situation, the copyright infringement in short video will be released. But the reality is it's the same, because they only need to take down the infringing video which named by the notice. So it means they're facing the same challenge is if the infringing video go beyond the notice, no matter it's the same type or same one, they have no responsibility to take those infringing video down. So it means the whole situation will go through again and again, and the same type of or the repeat or reappearance infringing short video would never end. So that's the reason why I said that the current notice and takedown procedural lack of its effectiveness now. But But luckily, there is a new system was first proposed in the report article section 512 of the Safe Harbor published by the U.S. Copyright Office, because in that situation, the duty of care and duty of filtering and the liability of a copyright infringement are strengthened at the same time, because they also mentioned that this is a single responsibility of the service provider to prevent the reappearance of the same or similar infringing content. And also under that framework, then a takedown notice from a right holder generally triggers a duty for service provider to proactively identify and remove all instances of the infringing contents and prevent further upload. And they also mentioned that they can depend on a various filtering system in order to meet obligations under this duty. So I think therefore my research consider that this such system would be a very good progress for effectively regulating the massive and repeat short video copyright infringement issues. And also I think this system can be independently applied to the copyright system, even though the safe harbor will be waived in the future. But this system is still very useful for addressing the short video copyright infringement issues. And my last finding is more related to the liability regime for the copyright infringement. So currently China, they didn't have a specific IP liability regime or copyright infringement liability regime. So at first, China should considering to specify the liability regime for the copyright infringement or IP infringement liability. And under these issues, I think US and EU's copyright law, they are more advanced and certain and clear than China. But however, compared with the US and EU's copyright framework, I think EU's regime is more in line with the current development of a short video sharing platform, and because they are setting up the different level of liability for the copyright infringement on video sharing platform based on their active users numbers, scales, and the profits they have. And now I will show you some examples about that. The first section is the U.S. Copyright Act. As we can see, the different condition, a different element will match the different infringement liability in this case. So it means if the short video copyright infringement disputes go to the court, and then court can, based on the different element, to corresponding the different infringing liability for the short video sharing platform. And then they're quite certainty and clear how to identify the infringement liability for the platforms. However, the next section is the Chinese infringement liability regime. They are using the same civil infringement liability regime, and also plus with the vaguenesses and confusion of the identification criteria of the safe harbor. At the end, when the things go to the court, they're also quite difficult to determine how the short video sharing platform need to bear, what kind of infringement liability at the end. And now I want to spend time to explore more detail on the EU directive on copyright law in digital single market, Article 17. And that's what I mentioned before, how they make a development and progress for the innovative regime.
I'm sorry to interrupt. You've got 7 more minutes. 7 more minutes.
Yeah, no problem. Thank you. Okay. And now we can see Article 17.4. They have the terms related to if no authorization is granted. And then increase and strengthen the effort and duty of care and duty of the monitoring and duty of review for the video sharing platform, because that's exactly what happened for short video sharing platform, because they have a lot of videos on their platform. They don't have any authorization, but however, the short video platform, they don't need to do anything about that because their information storage space, so they don't need to ask any authorization for the video upload by the users. And also, they also considering the type, the audience, and the size of the video sharing platform, and the type of work and subject matter uploaded by the users. So it means they're not only considering in a single way, they're considering a multiple elements for one video sharing platform, and then they separate it as a different level to considering the different liability for them. And I think that's the most. I think that's the most important section that they separate, like, as the different annual turnover with the different limit of the money they earned and the different average number of monthly unique visitor of the different video sharing platform. And they also putting exactly the word mentioned that if you earn more money, and then you will have made more effort to prevent the further upload for the notified works. So it also in line with what my research want to pointing out is, like for example, TikTok. I also do the research said that the TikTok actually satisfy the requirement which is setting up by the EU copyright directive. So it means they need to make more effort to prevent the reappearance or further upload of the notice words to appearing again on their platform. But however, based on the current safe harbor provision, no matter how big tech you are, even the TikTok, the only obligation or responsibility or the only duty of care is to wait for the notification and delay the infringing short video. I think that's not reasonable anymore, and not even like efficiency anymore for regulating the short video copyright infringement issues so far. So now I'm bringing the conclusion now. So when I'm considering China's aspect, I think China should consider to reforming the current the current provision of the regulation, and to improve and enhance the safe harbor provision and the notice and takedown procedural. And because of the US and China, they're sharing a similarity for the same safe harbor provision. So I believe if the same situation or same challenge happen in the US, they won't be able to handle the same issue based on current copyright framework as well. So for the US copyright framework, they also need to consider amending its copyright to address the same issues. And for the EU copyright directive, I think so far for what I'm seeing is they're more advanced than the China and the US. So I think for addressing the repeat and massive short video copyright infringement, the EU will have a better performance than the China and the US. However, if considering the detail of the EU copyright directive, and there's still a room to improve, because that's still have a lot of different another type of a short video copyright infringement behavior exists. So, and that's my presentation today. Thank you. If you have any question, just feel free to ask me.
Thank you so much, Benji, for that presentation. I'm going to invite our discussants and commentators. The first is Dr. Georgia Jenkins. Dr. Jenkins, you have 5 minutes, please, to discuss and comment on the presentation. Thank you.
I honestly thought this was a really interesting presentation. I'm really excited to see how your research develops in its final product, because I think there's been so much focus on the EU because it's always at least with what's happening at the moment in the EU, it seems to be a first mover, and people kind of assume that because you're first, it must be effective legislation. So having the comparison with China and the US, I think it's really original. And yeah, as I said, I can't wait to see what you end up coming out with. I had a few questions and a few comments, just things to bear in mind. The first one has to do with your methodology. So you're doing a comparative approach, and I just wanted to kind of flag a few things. Maybe you haven't thought of them yet. The first is with Article 17 of the DSM directive, it's a directive, right? So the EU member states have implemented this differently, and this is a huge problem. So we're going to see lots more referrals to the Court of Justice on what the directive means. But in terms of your research, are you thinking about including member state perspectives? So a few I'd point out, for example, Germany has a very user-friendly implementation, which caused a lot of uproar when they published it. Then you could look at France, which is very much authorial-based, right? So they want you to go to court to sort it out. So you might need to kind of unpick those nuances when you're doing this comparative approach, because it's not one brushstroke across the EU. Unfortunately, even though that's what they wanted to do to begin with. The other thing is to kind of, I don't know if this fits within the scope, but when you're talking about copyright infringement and platforms, maybe you also need to kind of set the boundaries of Article 17, because if you're not an OC, I always get this wrong, an OC FSP, then you're going to be liable under Article 3 of the Information Society Directive. So you might want to set out that there's actually two schemes operating and the implications of that. Additionally, you were talking about secondary liability from a US perspective. Again, the EU, not one big brush stroke. We've got different systems. So maybe it's a case of just saying scope of your thesis, this isn't included. I don't want to talk about it because it's too much. Because I could see this thing getting like bigger and bigger and bigger, and the less space you have, the easier it is to defend. Okay, so that was the comparative part. The second question I had or comment is about, and this is when I read your slides before you spoke, you're looking at what is effective here. What is good performance in terms of regulating what happens on platforms? So I kind of thought maybe you could unpack that a bit. Is it how many cases are successful? Or is it when you look at the legislation, and I do a lot of EU copyright law, I'm not really familiar with the other jurisdictions, but the whole context and background of the DSM directive was about this value gap between authors and monetization on platforms. So is it about striking a balance? So maybe looking at the recitals of the DSM directive to kind of unpick that. And that kind of brought me to this other thing, which I think you're getting at a little bit, which is we're seeing this change in the internet's infrastructure. We had safe harbors from the early 2000s, and now the platform is taking on a completely different role, and the law doesn't match. And so the EU has tried to solve this. So maybe it could be interesting for you to kind of look at what is platform theory supporting this? How has the platform changed, and what have scholars said about it that reflects this change in terms of legislation? So there's an author that might be helpful, Thomas Noel, who's written a book on platform theory. You might have come across it, but just to give you context on building that narrative as to why this change is important. And that leads me to another question, which is, so if platforms are taking on this huge role for content moderation, there are implications for other interests like users, for example, which you do note in your presentation. There are problems with the EU perspective. But I suppose, is fundamental rights something you should also be kind of considering here? What responsibilities do platforms hold to users in the way that they moderate content? And does the EU do a good job in doing that? Because we've had the Polish referral to the Court of Justice. We've also had guidance from the Commission. And my view on it is that none of this makes sense. And we're going to see tons and tons of referrals. So this might be one thing that China could learn from and say, actually, we need a better kind of approach to freedom of expression.
Dr. Jenkins, 1 minute.
Yes, am I going? Oh, 1 minute. Okay. So I've talked about platform theory, what is effective, the role of platforms. Okay, two more things. are you going to consider things that are like exterior to copyright that impact regulation? So like the Digital Services Act. Yeah, okay, good. I was like, that needs to be in there. And then the other thing was, and I really liked it, you were talking about what is a short video format, and you conducted your own research, 3 seconds to 10 minutes. I just wanted to say the German implementation of the Article 17 gives you set definitions of what is a minor use. So maybe this leads to a broader question of, in terms of infringement can be manifestly infringing, like a copy-paste scenario, but it could also be user-generated content. And the German law might help you in figuring out your subject matter and kind of refining the scope. And I'll just leave it there because I have a lot of ideas, but I'm happy to talk to you or email later about it if you want as well. But yeah, it was excellent.
Thank you very
Thanks,
much.
Thanks, Dr. Jenkins. The two of you can meet after the presentation, definitely. That's the essence of this meeting anyway. Next, I'm going to invite our colleague, Dr. Patrick Masiyakurima, to make comments. Benji, you are going to reply after all of the comments because of our time limits. So you're welcome to make your comments, contribution.
Yeah.
Dr. Patrick.
Yes. Well, your presentation was excellent and very informative, and I look forward to seeing the final output. I have a few comments to make, and some of them have already been addressed by Dr. Jenkins. And I think there is still scope for refining the comparative element of the research, because if you look at China, it is primarily a civilian country, and the US is not. And then I think you have to justify why you are comparing the two systems. But I also think that perhaps the focus of your research at present is on the rights of copyright owners, or the rights of those short videos and all the like. But perhaps you should look at the rights of users in some detail, and your definition of short videos suggests to some extent that perhaps there are issues as to whether the use of those short videos amounts to substantial infringement, because if it is so short and it does not really reflect the substance of the work it is copied from, then there are questions as to whether there is substantial infringement at all. And if there is none, then all those comments on takedown notices and digital markets and all the like become irrelevant, because there is no infringement. And perhaps one can also look at whether there is any economic harm which arises from such formats at all, because in some instances the opposite is true. If there is a short clip which is played on the internet by a user, it may publicize the original work so much, and the original work might be sold as a result. So there are issues to do with substantial infringement. There are also issues to do with defenses. Sometimes these short videos are employed in the form of parodies, for example, or quotations and all the like. And once you look at it from a copyright owner's perspective, then I think you are also missing slightly the other side, that perhaps there is no infringement because there is no substantial infringement. And if there is, then there are certain defenses which are applicable to in the circumstances. So those are some of the things that you should look at. And of course, the idea of freedom of expression also arises in general, because some of those short videos are a commentary on the news or other aspects of the day, and all those things perhaps require some consideration. Of course, the broader issues that were referred to by Dr. Jenkins are very, very pertinent, especially in relation to EU law. As you know, directives may be implemented differently in different countries, and perhaps if you are referring to the comparative elements of the thesis itself, you may have to choose maybe one or two EU countries which have implemented the things you are looking at differently, and look at the implications of the different implementations. Otherwise, it will be too long, and if it becomes too long and you're comparing everything, there is usually a little room for discussion, and the thesis itself might suffer as a result. But otherwise, I am looking forward to reading the whole work. It is excellent, and subject to some tweaks, it should be a very, very good project.
Thank you.
Thank you very much, Dr. Masiyakurima, for your comments. Because of our time, I quickly invite Mr. Bernardo De Mello to join the commentary. You're welcome to make your comments, please.
Just a quick comment. I'm not a specialist on copyright, but I think I'm echoing both professors when they're talking about the methodology of using comparative methodology. So I think making it explicit what guided your choice in terms of US, EU, and China. Why did you choose the jurisdictions? And the follow-up thing that you should be very evident in your thesis is to how do we all account for those differences? And I think Professor Jenkins was talking about this. So how do we account for civil law, common law? How do you account for the fact that you're talking about EU law, that it's not a country? So and again, it's a more of a matter of justification, not necessarily, you don't have to solve the question. And my final comment / question would be, since you are comparing, and again, and I think they both touched on this subject, is to what extent do the cultural and social attitudes towards copyright, how they influence how the copyright in this issue in short videos will be used either in EU, and if you focus on a specific country or countries, and in China and the US. And again, I don't think you have to write a sociological treatise on the views on copyright, but when you're talking about the comparative methodology, showcasing that, okay, China has this view on copyright law, thus I'm using this as an example. This contrasts to the US view, sociological, political view on copyright. I'm using the US. There are convergences and divergences, but here's my work focusing on these 3 jurisdictions, hence the question. But other than that, I think it was very interesting. I love the presentation. I think it's very structured. I could follow, again, even though I do not understand copyright law, I could follow each finding and each question. So congratulations. It seems a very, very, very good thesis.
Thank you so much, Bernardo. I would like to invite any member of our audience, if anybody has have a question to ask, raise up your hand and you could ask. Does anybody want to ask any question in the room? Okay, if there's Erica, you're welcome. Please, Erica Moore, yes, please, your question.
Hello, good afternoon. Menji, it's very fascinating. I have a very short question related to methodological application. As you have mentioned rightly, there are first, I would say, shining stars coming out from the EU directives. The EU countries, they are under the obligation to find the responsible and effective way how to harmonize, how to approximate, and how to implement that directive into their own legislation. I truly admire your comparative and empirical approach with the US and China, it's a massive topic, but it needs to be resolved, and I appreciate your input. It's absolutely mind-blowing. And do you feel that the same pattern can be used in those giants as we address them? Because the EU has many little countries, many little states with their very own autonomous, well-functioning, independent governments and their own legal system, which works the small, very important democracies. But if you would, for example, find a way how they do approximate and how they do implement and harmonize this massive directive, you perhaps can compare how this would fit within the Anglo-American and legal system, and as well within a common law, because you are as well dealing with continental legal regime and the continental law system. Afterwards, you have a common law because of the US territory, and you have a China, which is again another very much Asiatic element to it, which Law Asia would be able to perhaps as well help you directly, and they would be able to provide you with many useful informations. So do you think it might worth it to try to use the same tools of implementation as the European Union is using within those two massive territories? That would be my first question, if you consider that this might be the case. And the second question would be related to China.
Erica,
Yes?
I'm sorry, we have just one more question because we have 4 minutes. So maybe after the meeting, you can.
How you deal with the many regions which are within the China, because many of them do functions independently and they're fully autonomous. So, for example, if you have one, let's call it a directive for China, obviously there will be another one which would be, for example, regulating the Beijing, because the Beijing is a part of a completely independent governmental autonomous area. So perhaps that would be another question, if there will be a sub-governmental directive, for example. Thank you so much.
Thank you, Erica. Last question, Mr. Siri. Sorry. Okay. So last question, please, because we have 3 minutes to finish this. I know you all have questions, and you can meet with Menji later. So your question quickly, please.
Hello, Menji. It's very interesting, the area. It's somewhat, it has some bearing to my research area as well. But I have 2 questions. I'll put it very shortly to you. One is as per the WIPO guidelines, it says even the recently concluded SCCI, I don't know whether you followed the short video, it's 30 seconds to 2 minutes, but I saw you are expanding it, which is very good, so that you kind of bring that in. So do you have any kind of what base you are going to take on that? That is first question. And secondly, it's something related to my one as well. Are you touching on the limitations and exceptions, especially in line with the WIPO guidelines for the short videos, or you're going on general limitation and exception? That's it. Yeah. Thanks.
Okay.
Thank you all for your comments.
And first, thank you very much for all the question for me was very amazing. I think it really gave me the inspiration for my research as well. I think the most common question I get for all the commentary is about if I'm looking for a specific or narrow down the area for some EU countries. Yeah, I think that's a very interesting question. The reason why is, that's when I was my 2nd year or 3rd year of my PhD, I think about that. But I think the most challenging and the most focus for my research is more about, I'm still on the beginning stage to breaking up the traditional regime, because I can understand how important to understand and recognize there have a more, maybe a better process can improve the short video copyright infringement issues. But I think the condition is the China or the EU, they're starting to making change. The main thing is they still maintain a very traditional versions for regulating the short video, which the safe harbor provision created like over 20 decades past. They're still using that regime to regulating a short video issues. And also, I think all we know, short video is quite a new thing for the copyright market or video, online video industries. So I think there is no sense for still applying that kind of old version regime to regulate these issues. And so for my research, the first step I want to do is trying to try to notify them. You need to make change now, since now. I think maybe later on, when we have a further step, and then I think we can improve more another country's specific progress on that. But I think the first thing what I do is I'm trying to reminding people it's very important. It's a time to reforming. It's not reasonable. It's not reasonable still applying that to regulate the short video issues. So that's the reason why I'm more looking at a general EU copyright directive, because comparative the traditional safe harbor, the copyright directive, I noticed that there is some also have many issues on applying the EU directive, copyright directive. However, comparative to safe harbor provision, we have to admit that they really make a big progress on waiver the safe harbor provision since the 2019 they having the new copyright directive. So I think that's what I'm trying to do now is I'm trying to remind them there is still a different regime for regulating the copyright infringement issues. So maybe you can have a look, or maybe you can refer from that experience as well. And that's the first question I would like to answer. How many minutes I left? It's fine. If time, okay, 2 minutes. And another question I would like to mention that yes, the Digital Service Act and Digital Market Act and copyright directive, I all mentioned that in my thesis because I think they are also pointing out very important how they separate the different level of the different platform to take the different responsibility. So I already put it in my thesis, but sorry for the limited for the presentation. I trying to put a lot more, but I can't. But thanks for reminding me for that. And another one is about, and there is an interesting question as well. I think Patrick mentioned that if the short, like accountability for if the short video have copyright or not. And I think that's already exists on the China's jurisdiction. There also have some case. And there also the reason why I extend the duration from to 10 minutes. It's about, I think I'm trying to explain. For example, if we write something, we are not depending the originality for how many words we write. Even 1 pages, even 10 seconds, if we create it by ourselves, there is still have originality exists on that video or at 1 pages. But the main thing is my research is more looking at the video clips for online user, they editing from a copyrighted work. There is a lot short video clips which like move or editing from like a movie, television, and they're using that to increase their number of views, number of plays, and then the advertisement company will go for this kind of online user with the high hits. And then I would say, would you mind to input one of the advertisement into your videos, and then they can earn money from that. And we can understand that in that even 2 minutes video clipped from other movies or television, they still have a huge commercial value and originality from it. So I think I didn't make it very clear in the beginning. So my research is more not looking at a general short video copyright infringement. So I'm more looking at how those short video already infringed, but there is still existing amount number of those the same type or similar type of short video on the platform. So I think in this,
Thank you very much. Please proceed, Professor Taiwo.
One last word. Sorry. Please feel free to email me. We can have a small meeting about that.
That's the good thing about these sessions. These sessions are recorded, so all of these responses, questions, you can rewind, play, pause, whatever you want, you can note it down. So that's a good thing about that. That will be, you will be notified very soon. Please,
thank you. Thank you, Menji, for the excellent presentation. But before we go, I just want to make these comments very short. Please don't completely discount what Dr. Patrick said, because somebody who edited a short video clip from a lengthy copyright subject matter may also claim accreditation for their editorial judgment. So you might be talking of derivative work and all that. So, okay, anyway, so I'm not going to go into all that because we are out of time. Thanks to everybody who attended this interesting meeting. This Global South Network it's a weekly event. Like I said previously, it goes on until December every week. So the next presentation is going to be on the 15th of January. And it's going to be post non-interference, a critical appraisal of Article 4H of the Constitutive Act of the African Union in international law. And the presenter is from the University of Uganda, a PhD candidate. Makerere University, Uganda. So, excuse me, I'm rushing because I know some of you are probably going somewhere. So again, you are welcome to attend next week's presentation on the 15th, same time. And Happy New Year once again. So good luck, everybody. Take care and catch up sometime. Bye.